Good afternoon. Tomorrow is the 4th of July, and tomorrow we celebrate the 242nd anniversary of the Declaration of Independence, the 247th anniversary of the birth of our nation. And as you all have probably heard before, there are three concepts that the Declaration of Independence is most known for. The concept of life, liberty, and the pursuit of happiness. Those things form the basis of our free society. And if you think about every document, every patriotic song, everything that we say we're about freedom. And I start out talking about freedom, not because I want you to wax patriotic and not listen to the evidence. I start out talking about freedom so that you will know that today, what is at stake is a most precious right that we all love and cherish. What is at stake today is Mr. Richardson freedom. So today, your verdict has to be a careful and reasoned decision. It has to be a careful and reasoned decision. And that's why I talk about freedom. I understand in this case that there's a 22-month-old child who's deceased. And I know you all understand it. And when we did jury selection, we told you, we don't want you to stop being human beings because you sit in this jury box. Because we know that this is a sensitive case. But I ask you today, as you consider the evidence in the law, that all the sympathy that you must feel, that you probably feel, for Ada McClendon's mother, his grandmother, and his great-grandmother, that you feel it, but you put it in a box, because it has no place in your verdict today. And this week, and last week, you've seen a lot about an aspect of life that you probably were not aware of. And you may be disgusted that it goes on. You may be shocked, you may be surprised. But I ask you all to put that in a box, because those feelings have no place in your verdict. How do you, as jurors, make a careful and reasoned decision in this case? What is it that you must do and know? The first thing you must know is, what is the burden of proof in this case? What is the standard by which you are to govern all the evidence that you've seen in this courtroom? What is the standard, and how do you apply it? The standard is beyond a reasonable doubt. That is the standard by which you are to judge all the evidence that you've seen. The judge is going to instruct you on beyond a reasonable doubt, but I like to spend a little time with it because I think it's important that you know what the standard is in this case. The instruction starts out saying a reasonable doubt is not a mere possible doubt, speculative doubt, imaginary doubt, or forced doubt. Not a possible doubt, speculative doubt, imaginary doubt, or forced doubt. Those things can't lead you to the conclusion that there is no reasonable doubt. But they also don't form the basis of those things can't be reasonable doubt, but they're also not the basis of that. There is no reasonable doubt. We're not here to deal in probabilities, possibilities, imaginations, or forcing yourself to believe one thing. The instruction goes on to say, such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. What does that mean? It's telling you that if you have a lasting conviction of guilt, you have no reasonable doubt, and you should find the person guilty. What does abiding mean? What kind of conviction of guilt must you have before you find Kwame Richardson guilty? An abiding conviction of guilt. And what does that mean? In the context of this sentence, that means a lasting conviction of guilt. A lasting conviction of guilt. What does that mean? I like to explain it like this. Do you have a conviction that Kwame Richardson, to the exclusion of every other person in this world, committed this offense? Do you have that kind of guilt, conviction before you find him guilty? And if you think about it this way, if you had to render your verdict tomorrow, will your verdict be the same? If you had to render your verdict next week, will your verdict be the same? If you had to render your verdict 10 years from now, would your verdict be the same? That is the kind of conviction of guilt you must have before you find a person guilty. You must know that I am not going to change my mind ever again once I render that verdict. The instruction goes on to say, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is not stable, but one that wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. And isn't that saying the same thing? If you're wavering and vacillating, if you're going back and forth, if you're not sure, you don't have an abiding conviction of guilt, and you must find Mr. Richardson not guilty. What is the evidence in this case? What evidence do they have in this case against Mr. Richardson? Let's talk first about the car. The car that was used as the murder weapon in this case. Let's talk first about who we know had the car. Sanquan Bradford had the car. He admitted to you that he carjacked the car. The woman that he carjacked the car from, the pregnant woman, told you Sanquan Bradford took this car from me. So we know for sure that Sanquan Bradford had the car. Let's talk about the text message that Sanquan Bradford sent to Henry Hayes shortly after he carjacked that white car. But let's go a little bit back. What do we know about Sanquan Bradford? He had 2 stolen cars that night. He had 2 stoners that night. He told you he had a gold Lexus and a white car. What else do we know about Sanquan Bradford in that car? We know he argued with his co-defendant, Lil Ron, about driving the nicer car. Remember, that's what the victim told us. He said, no, I was arguing about something else. I really wasn't involved with that. What did she say? She said that the shorter one, Mr. Bradford, person she identified as Mr. Bradford, not only put a gun in her face and kept demanding money, but he also said, why do you always get to drive the nicer car? He wanted to drive the nicer car. Why is that important? Because why would he argue about driving the nicer car if he's just going to sell it 10 minutes later? Why would he care if he's just going to get it and give it to somebody else? Because he wasn't. He was going to give the not as nice car to somebody else. Not the white car. So you all ask, how did Mr. Richardson's DNA get on the white car if Mr. Bradford didn't give it to him? Think carefully about the testimony regarding the white car and how it was processed. Think carefully about what Detective Pfister told you about how she swabbed that car. She told you with regard to the front part of the car, for the interior passenger, she swabbed the steering column, the area around the radio, because if a person was in a car talking, the DNA that would come out from their mouth would possibly be in that area. What did she tell you about how she processed the door, which is where Mr. Richardson's DNA was found? On the interior door, interior driver's door. Now, she told you that before she did that DNA swab, she attempted to lift fingerprints from the door handle, and she used some sort of tape. But she couldn't lift, she didn't find it. But what else did she tell you? She said after she did that, she swabbed the entire door. But she specifically said, I swabbed that top part of the door where your arm may rest when you're driving. Like this, if you're driving and you have your arm like this. Remember she said that? If Mr. Richardson met with Mr. Bradford and Mr. Bradford is sitting in that driver's seat of the car and Mr. Richardson is talking to him, his spit could have gotten on the driver's door just from talking to Sanquan Bradford. He didn't have to be inside the car for his DNA to be left on that door. That is reasonable doubt. He did not have to be in the car for his DNA to be left on that door. Remember, inside that car, from the various swabs, the DNA expert told you that those swabs contained from at least 2 people's DNA to at least 5 people's DNA. There were many people who could have been in that car. But what did the victim say? She said she just got in the car. She hadn't really let anybody be in her car. So was Sanquan Bradford driving other people around, or were there other people around in the car? Sure, because there's at least on one of the swabs there was DNA from 5 separate people. Now, they couldn't determine, it wasn't enough for them to determine who it was or to get a match or anything like that. But there certainly was DNA from a lot of different people in that car. Mr. Richardson's DNA did not have to be left in that car from driving it, from being in it. He could have been on the outside of that car. That is reasonable doubt. And ask yourself, when you think about it, with regard to the DNA, do we have any proof that the DNA was left there at the time of the shooting? Was the DNA left there at the time of the shooting? We have no evidence that that is in fact what has occurred here. And remember, with regard to the car was found on February the 2nd. And it was sealed up and taken to the lab or taken to the warehouse on February the 3rd. Remember when this incident occurred? On February the 29th at 6 o'clock. Now, there was some testimony that an anonymous tip came through and the car had been there for a couple of days, like the 2nd. I submit to you that that anonymous tip is not reliable. Who calls in an anonymous tip for a car that's sitting there? Why is it an anonymous tip? Why was there nobody to speak with the police officer? Because the person who called that car in knew about it. But let's take the anonymous tip at face value and say, okay, they're right. So the car was there from at least the 1st. There was still 2 days after the incident. Can you say with assurance that Mr. Richardson's DNA was left in the car at the time of the incident? Let's talk about the gun, because that's another piece of evidence against Kwame Richardson. Now, what we do know is this. Sanquan Bradford told you all, I had the murder weapon. Now, how does he know that he had the murder weapon? How does he know that the Glock 26 used in this case was one that he had? Because he committed the shooting. And remember, Sanquan Bradford did a video on January 6th where he said, in my hand, that is the murder weapon. That's what he said. But he, of course, said, well, the day after, I sold it to Kwame Richardson. Remember, I asked Mr. Ladizabal, can you look at these photographs and determine what type of gun this person has? And he said, I can look and I can generally tell you. And he could generally identify some of the firearms that he was shown. But when he was shown the photograph that contained the gun that Kwame Richardson had in his hand, he could not say that that was a Glock 26. The state is saying each and every time after January 6th that you see a photograph with Kwame Richardson, that's the murder weapon. They have no proof that that is the murder weapon. You cannot look at that gun and identify it as a murder weapon. If Sanquan Bradford says that that's the murder weapon, he must know that that's the murder weapon because he committed the murder. There's no way you can look at those photographs and tell what kind of gun it is. That it's a Glock 26, that it's some different kind of Glock, that it's any kind of Glock. There is no way. So the state can't credibly claim that each and every time you see Kwame Richardson with a firearm in those photographs, that that's the murder weapon. But let's talk about the fact that Mr. Richardson's DNA is found on the gun. First of all, when we talk about the car, which is 1 in 700 billion, versus the DNA on the gun, what you do know is that it's not as conclusive. Because, as Mr. Hutton explained to you all, well, his explanation was a little different from what the DNA expert testified to. Because what the DNA expert testified to is what they call a probability ratio. And what she told you that meant was this. They compared two separate hypotheses. One is that there are 3 contributors who are unknown, not known to anybody. And the other proposition is that Kwame Richardson and 2 other unknown persons contributed DNA to the firearm. So they're testing those 2 hypotheses. And so what does it mean? So when you say it's 540 times more likely that Kwame Richardson and 2 other people contributed DNA to the firearm versus 3 unknown people, that is what the probability ratio is. It's not, it's 540 times more than what? You wouldn't even be able to determine what kind of standard that was. Is it 540 times more than 0? I mean, so you have to have 2 things that you're comparing it to for that to even make sense. But what else did she tell you? She said that when you look at the probability ratio, you also have a chart that they refer to. And the probability ratio of 540 is what they would say is a strong probability that Kwame Richardson and 2 other persons contributed DNA to that firearm. But what else did she tell you? She said that if you look at the probability ratio, it's from 1,000 to 1,000,000, that's an extremely strong probability ratio. So we have a probability, a strong probability, we have an extreme probability. Those are 2 different things. Is a probability, a strong probability, is that proof beyond a reasonable doubt that Kwame Richardson's DNA is on the firearm? It is not. But let's talk some more about the firearm, because what else did the DNA expert tell you? That there were at least two other persons' DNA on the firearm. 2 other persons. And not only did she tell you that, but she indicated that using their software, they actually had what they call contributor 1, contributor 2, contributor 3. Contributor 1 being the person that under their software had the most DNA on the firearm. And then there's contributor 2 who's second, and then contributor 3 who's third. Now contributor 1, given their software, according to this, their standard would have contributed 46% of the DNA to that firearm. Contributor 2 would have been 33%, and contributor 1 would have been 21%. So you have 3 people who may have possibly contributed DNA to the firearm, and relatively, although different, but not that different in terms of how much they're contributing. So then the question you must ask yourself, is there proof beyond a reasonable doubt that during the course of this incident, Kwame Richardson had the firearm? Now, what you can't find is that Kwame Richardson was driving, because his DNA is on the interior driver door, and he was shooting because he had the firearm, because it's logically inconsistent. He could not have been doing both. He couldn't have been driving and shooting, although his DNA is on the car, at the driver's door, and on the gun. So what does that mean? How do you look at that in terms of this case? What we do know is this. Ms. Brown indicated that Henry Hayes was hanging out the back of the car with the gun in his hand. And remember what she said. She said his body was out and he was holding the gun like this. And that's the motion she made. He was holding the gun like this, which means that if there are 2 weapons used in this offense, one being the rifle, one being the handgun, then the gun Henry Hayes must have had would have been the handgun. It must have been the handgun. And how do we know that? Remember, all the shell casings that were found at the scene, all the shell casings that fell outside the car came from the handgun, which is consistent with the way Ms. Brown said Henry Hayes was hanging out the car shooting. Remember, they found 1 shell casing from the rifle. 1, which means whoever was in the car with the rifle was not hanging outside of the car, because all the shell casings went inside the car. Henry Hayes had to have had the firearm, the pistol. And in fact, Ms. Brown said initially he didn't have the rifle, that he had the pistol. So if Henry Hayes has the firearm in his hand during the shooting, the fact that Kwame Richardson may have contributed DNA to the gun does not make him guilty. Think about this. If Henry Hayes is the person hanging out the car with the gun, the fact that Mr. Richardson's DNA is on the gun doesn't mean that it wasn't put there during the crime. It wasn't put there during the shooting. Now, the state may try to say, well, Kwame Richardson probably gave that gun to Henry Hayes. Do we have any proof of that? Do we have any proof that Kwame Richardson gave the gun to Henry Hayes? But what we do know is this. If Kwame Richardson had the gun on February 7th, 10 days after this incident, why would he have a gun on his person that he knew had been involved in a shooting, a high-profile shooting that everybody was talking about? Is Mr. Richardson the driver? Is he the shooter? What proof do we have of each of those? We have no proof. Let's talk about Jamari Brooks, because the state indicates that Mr. Brooks identified Mr. Richardson a couple of hours later at a gas station on 45th and Moncrief. Let's think about this. When Mr. Brooks testified, he clearly identified Henry Hayes, called him Cracker, or Cracker Jack, I can't remember which one. But when he got to Mr. Richardson, what did he say? His exact words were, "They say it was JB." Like he hadn't even seen the person. And remember, when he testified, he didn't even point to Kwame Richardson. The state did not even ask him to point out Kwame Richardson. Why is that? Because he never identified Kwame Richardson as being outside of that vehicle with Henry Hayes. Remember, all the witnesses who came in here and said something about Kwame Richardson, they said, point him out, tell him what he has on. They didn't do that from Jamari Brooks. He didn't identify Mr. Richardson. Let's talk about Cynthia Hayes and Henry Hayes. Now, Mr. Hutton made much ado about, oh, JB and Cracker Jack are best friends. Let's think about that. Mr. Hayes' dad told you he didn't even know who Kwame Richardson was. I don't know him. He's never been around my car. I've never seen him with my son. But the state would have you to believe that they're joined at the hip, that you can't see one without the other. But Mr. Hayes said, I don't know him. Now, his sister said that they were good friends, but his dad said, I don't know him. But let's talk about their testimony. First of all, Cynthia Hayes, when she was out there that night, she admitted to you that she never told the police that Mr. Richardson told her anything about the firearm. Excuse me. She told you that. Additionally, she also told you that she was looking at 60 years for RICO, and she would do anything not to go back to jail. She had spent 8 months in there, she had a baby in there, and she would do anything not to go back to jail. What did Mr. Hayes tell you? I was there at every single hearing for my son. Didn't miss one. I knew everything that was going on with his case. Yet, Mr. Hayes doesn't come up with this statement until Thursday before the trial. More than 2 years after his son had been arrested. He never tells a single person about this statement. What did Ms. Hayes tell you? She never told anybody about this statement until 2 weeks before, when she got her get out of jail free card. That's when she told them she heard this statement. But let's look a little bit deeper. The statements that they heard were different from each other. What did Mr. Hayes say? He said that JB said, that was my gun in the car. And he even said, the state asked him, what was his reaction? He was like, he just said, that was my gun in the car. And I'm going to turn myself in. What did Cynthia Hayes say? She said that although they were together, Mr. Richardson threw his phone down and said, I'm going to turn myself in. I submit to you that Ms. Hayes was trying to help herself, help her brother, and Mr. Hayes was trying to help his son. Mr. Richardson never made those statements to them. And I submit to you, there's no proof beyond a reasonable doubt that he did. Now, there's been a lot of talk in this case. Oh, I'm sorry, let me go back to one other thing. I want to talk to you about the text messages that Mr. Richardson sent to Mr. Bradford the day after the Super Bowl. Now, what we do know about those text messages is that they've been altered somewhat, because Mr. Bradford told you that he had deleted some parts of them. And what did he tell you he deleted from them? He told you, I deleted the part where Mr. Richardson talks about a Glock 26 and how the police had it. Why did he delete that? Let's think about it. There are a lot of incriminating statements in those text messages between Mr. Richardson and Mr. Bradford. They're talking about trading guns. Mr. Richardson says, I have a 23, and they're talking about a K for a 21. There are a lot of talk about guns. So Mr. Bradford is not concerned about the police finding him talking about guns. What he's concerned about is the police find him talking about that particular gun. Remember, those are Sanquan Bradford's messages, not Kwame Richardson's. And why is that? Because Sanquan Bradford knew that that firearm had been used in a murder. So you ask yourself, how did Mr. Richardson get it? Let's think about Sanquan Bradford. Now, the state wants you all to believe that he's afraid somebody's going to hurt him, but look how his demeanor was on that stand. Did he appear to be afraid? No. He was happy, he was relaxed, he was jovial, he was smiling. He did not in any way appear to be afraid. How do we know that Sanquan Bradford is the person who was in that car with Henry Hayes shooting? How do we know that? He confessed to Ashley Clark. Now, the state wants you to believe that since Ms. Clark apparently has slept with several of these friends, that she should not be believed, that she's a pass-around. And I submit to you, why would he do this for her? Let's think about this. He's an 18-year-old, and she's a 29-year-old. Why would he do this for her? Let's think about this. When I think about this, there's a movie called Harlem Nights. And it was the 1989 movie, which was about a 30s speakeasy type of atmosphere where they were involved in all kind of criminal activity. Well, one part of the movie involves this guy whose name is Richie, and the major players in that movie are trying to get Richie to do something for them. So they go to the local madam, and they say, well, can you get one of your girls to turn Richie out? And she's like, yeah, I have this girl they call Sunshine. So anyway, it cuts to the next scene, and Sunshine and Richie are in bed after sex. And Sunshine says to him, wow, I was really intimidated by you, so I kind of held back a little bit. So now that I'm not intimidated by you, we can do whatever you want the next time. And then Sunshine leaves and says something like, I love you, or something to that effect. And Richie gets on the phone, calls his wife and says, look, I'm never coming home again. That's why Sanquan Bradford did what he did. He's an 18-year-old kid who slept with a 29-year-old woman. Empires have been toppled by men's lust. They want you to think, oh, she's a pass-around. No, he wouldn't do this for her. Empires have been toppled by the lust of men. I remember a few years ago, there was some governor who went missing for like 4 days. Family didn't know where he was. The whole government didn't know where he was for the whatever state he was in. And guess where they found him 4 days later? With his mistress. I wish that Sanquan Bradford had picked a virgin who'd never been in trouble before to date and tell his story to. But he didn't. I didn't pick her. He did. He picked the woman who came in here and testified. The state was acting like he's some kind of great prize, and he's not. He picked her, not me. And guess what? Unlike the state, I don't have a get-out-of-free card, jail-free card to give her. I don't have anything that I can give her. They want you to not believe her because they indicate that she's a pass-around. But I submit to you, that's not a reason to doubt her. Remember what she told you back in March of 2016. She went to the police station. Well, no, she didn't go to the police station. She did a sworn statement where she told them that Sanquan Bradford had told her that she said that the actual statement was that he said that he took care of that for her. She told them that back in March of 2016. It's not something she just came up with, not something that someone coaxed her to do. She told them that back then. And how else do we know that she's not a pass-around or that she was more than that to him? Remember, when I asked him, I said, well, you were telling her on those jail phone calls how much you cared for her and that she was your girlfriend. And he said, yeah, because he knew that that was recorded. But he said, oh, I just told her that to get some commissary. I just told her that so she could give me stuff. But he knew there was proof that she was more than that. And that's why he said that. And what else did she say? She said that she tried to get rid of him, and he just kept showing up. Just kept calling, kept coming by, kept getting dropped off. She couldn't get rid of him. And why did he do it? Now, he may have told her that I did it because Ducci shot your daughter. But he has the same reasons to commit this crime as any member of this so-called PCA gang. So he didn't just have to do it for her. Maybe that was just icing on the cake that he could tell her that. What else did he admit? He admitted that he had the suspect vehicle. Now, he couldn't deny it. But remember what he said when he talked to the police? I lied because I didn't want to get myself cased up. Well, how do we know he's not lying now to get himself uncased up? For months and months and months he lied until he sent that letter over in August 2016. And by then he knew that he had no choice, that he had to admit what he couldn't deny. How else do we know that he was the person in the suspect vehicle when the shooting occurred? Because he told you all that he knew how to put tint on windows. Remember, he volunteered several times during his testimony that you could put tint on windows using, and I can't remember exactly what he said, but he said it several times. He knew how to put tint on windows. And he even said it'd be curled up and messed up and it wouldn't stay on. And that's exactly what we have in this case. He admitted he had the murder weapon. How do we know that Sanquan Bradford, who we know to be immoral, who we know will say anything to anybody to get what he wants, because he admitted that. How do we know that he didn't sell that gun to Mr. Richardson after the shooting, knowing that it hadn't been involved in the shooting? Do we honestly think he would care if Mr. Richardson got in trouble for a shooting that he had committed? He had the motive. If members of this so-called gang, PCE, had a motive to commit this drive-by simply because they were members of PCE, then Sanquan Bradford, who you saw his video on Facebook, you saw where he specifically mentioned 187, and he talked about being violent. He talked about if you can't fight, use your weapon. If you can't fight, use your weapon. Gang, gang, gang. He called out Lil Man, which is a member of 187. Called out D Rose. He said something about D Rose's girlfriend, Shatanya. And what does he say at the very beginning of this video? Y'all gonna make me do this. Y'all gonna make me do this. And what did he say that meant? That because 187 had specifically mentioned him in one of their videos, that was a response to that. If PCE, if Kwame Richardson had a motive, then Sanquan Bradford, who told you all that he was doing anything he could possibly do to get back in with these guys, he had a motive too. In the phone records. Now, two things you need to know about the phone records, and you know that Sanquan Bradford knew the significance of phone records, because when he was arrested, he denied that he had a phone. And on his Facebook post, He said, I'm going dark, I'm going to be in the shadows, I don't have a phone anymore. So he knew the significance of hiding his phone records. He knew that he could be tracked and located based upon his phone records. So why wouldn't he leave his phone at home while he committed this offense? Now, the state is going to show you those records and say, well, he couldn't have done this because his records show that his phone was home. Well, we already know that you don't have to be with your phone. We already know that he knows that a phone could be used to locate you. We already know that. But what else do we know? We know that the Sprint phone records are not accurate. And they say it on the paperwork. These records are not accurate. They can be used to find location, but they're not accurate. They're not reliable. It specifically says the text messages are not reliable, which is what the state is going to say, oh, well, he had to be home, because there are text messages going to his phone. But we already know that he knew that the phone could be used to track him. He sent the message saying he wanted justice for the family. 6 months later, but guess what? He didn't give anything up until he negotiated that deal. He didn't want justice for the family. He wanted to get out of trouble for San Juan. Now, the state, wanted to make much about, oh, he's in danger. He spent 28 months in jail in danger. Well, first of all, he hadn't been cooperating from the very beginning, so he hasn't really spent 28 months in jail in danger. But I'll take 28 months over life. I'll take a robbery over a murder. 28 months in jail where you face danger versus a life sentence where you face danger. Who wouldn't take that? He's not giving up anything significant because he's afraid in jail. Isn't this the ultimate power move on behalf of San Juan Bradford? He could say anything he wants, and he knows he's not going to be charged with this murder. I had the car, I had the gun. Is that any different from what they have on Kwame Richardson? I had the car, I had the gun, I had the motive. I confessed. He already knows there's nothing that he will say or do that would make the state charge him with this offense. That's why he was laughing and so happy and so charming. This is the ultimate power move on his behalf. As long as he doesn't say, I committed the actual murder to the state, doesn't matter what he says. Doesn't matter how he connects himself. Now, you've heard a lot of testimony about PCE gang. Now, I want to talk to you all about that. First thing I would say to you is this. When the judge talked about those specific instances of supposed activity, He read to you this instruction. The evidence which has been admitted to show other crimes, wrongs, or acts already committed by the defendant will be considered by you only as that evidence relates to proof of motive, opportunity, intent, preparation, plan, knowledge, and identity. You should consider it only as it relates to these issues. I want to talk to you specifically about each one of these incidences. The first one is the fight at the Kodak Black concert. That is what it is. There were two different people talking, I guess fighting over apparently nothing. Now, the next thing is the shooting and the killing of Avery Suge McKnight, or somebody they call Bink. And as Mr. Hutton told you all, he was a very important person to 187. But what we do know is this: there was no evidence that Mr. Richardson or any of his friends committed the shooting of Avery Suge McKnight. Now, in fact, 187 did a song because they were saying, hey, we're going to declare war on everybody because we don't know who did this and we don't have any idea who did it. There has been no evidence presented to you that Mr. Richardson or his friends committed this shooting. Now, I believe someone is saying that, in one of the songs, Kwame Richardson raps homicide upon the nation. And that's evidence that he killed Suge Knight, or PCE killed Suge Knight. I submit to you that that is not, or you cannot say beyond a reasonable doubt that that is what that means. These two people are supposedly beefing back and forth. Saying homicide upon the nation could mean we're going to fight with you, we're going to kill you, not we killed Suge. There was no proof at all that PCE killed Suge. Let's talk about the Christmas Day incident. Again, no evidence that PCE committed this shooting. In the next incident, the shooting at Cynthia Hayes' home. Now, what we do know is this, is that the opposing side came to Mrs. Hayes' home and shot up her home. But what was Kwame Richardson's reaction, according to Mr. Bradford? Kwame Richardson got Miss Hayes' child and went into the house with the child. So his instinct was not to pull out his gun and start shooting. His instinct was to take the child in the home. The next incident they talk about is the shooting of Killer Cam, the drug dealer's house. And of course, Mr. Killer Cam, Cameron Thomas, came in here and said, guess what? JB and Henry Hayes shot up my house. Why should you believe him? First of all, he said it was a brown van, not a white SUV. Second of all, he was questioned about it by the police 2 years ago, and he said nothing about it. And what did he tell you? Oh, I'm just doing this because I want to help the family. But he didn't want to help them 2 years ago. But what else do we know about that incident so that we know that Killer Cam is lying. Killer Cam is lying. We know that because of the video made by Henry Hayes. Remember the video where he's looking for some ops and he's in there ducking no action? Guess what he says in the middle of that video? Tico, hurry up. Tico, hurry up. Who's Tico? Montico Brown. The state wanted to make much ado about the fact that he makes that video at 9:48, and the shooting of Killer Cam's house is at 10:12. But Henry Hayes isn't summoning Kwame Richardson. Tico, hurry up. And if two people are the people who committed that crime, guess who are the people that committed that crime? Henry Hayes and Tico Brown. Not Henry Hayes and Kwame Richardson. Listen to Mr. Hayes' video. Tico, hurry up, is what he says. If there are two people, then it's Henry Hayes and Tico, not Henry Hayes and Kwame Richardson. The shooting at Victor's, Montico Brown was the person arrested for that offense. Not Kwame Richardson. So we have had 5 separate incidences, not one of which the state can show that Kwame Richardson even participated in. Not one witness other than Killer Cam, whose testimony is disputed, came in here and said that Kwame Richardson participated in any of these acts. So if these are all acts of PCE, then guess what? There are 30 people who had a motive to commit this crime. 30 people. If this is a beef between two rival gangs, 30 people who had a motive. Not 2, not 1, not 30. You're not going to hear an instruction that says, if you're friends with somebody, if you hang with that person, then you are presumed to hang with them every time they commit a crime. If you have a best friend, then you must be with them 24/7, and every time they do something, you must be with them. I want to talk to you a little bit about the gang aspect of this case. Now, these people have been identified as PCE. I will submit to you, there is not a single photograph where anybody identifies themselves as PCE. There's not a t-shirt, not a tattoo, not a single solitary thing where anybody says, I am a member of Problem Child Entertainment. All of these photographs, not one single thing that says PCE. The videos, even Henry Hayes talking, never says PCE. Think about it. Not a single solitary identification as a member of PCE. What did the state want you to look at in determining that these individuals are members of PCE? They wear rest in peace shirts, and they have rest in peace, I guess, for lack of a better word, dog tags. Not one of those t-shirts say PCE. And if you look at all the photographs that they have in evidence, on each of the photographs we have people doing different signs. We have the K's up for Kendra, V for Vontae Land, M for Michael, and there's also Dirkler, but I guess he doesn't have a specific sign. What do we know about those individuals? Those are all guys that these individuals respected. But have you heard any testimony that they were gang members? And if they're all in the same gang, why are there photographs where everybody's doing something different? When nobody's ever identified with the same clothing on. You're going to be given some instructions on how you are to evaluate witness testimony. And I want to call your attention to one. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with great caution, with more caution than the testimony of other witnesses. That is exactly what we have in this case. We have it with Cynthia Hayes. We have it with Sanquan Bradford. And finally, Mr. Richardson has not taken a stand in this case. He has not become a witness in this case. Now, in jury selection, all of you said that you would not hold it against him if he did not testify. I ask that you not hold it against Mr. Richardson that he didn't testify in this case. We believe that the state has not met its burden of proving this case beyond a reasonable doubt, and you should find Mr. Richardson not guilty. Thank you.